Good morning, everyone. I hope you can hear me. This is Madrid, the International Trademark System. If that's not where you're supposed to be, I think you should still stay here because this is going to be a great presentation today. My name is Alan Nemes. I'm a partner in the Husch Blackwell Intellectual Property Group, and thrilled to be able to present to you today. Before we begin with the nuts and bolts of our presentation, we have a few housekeeping items. We're not going to tell you about where the bathrooms are because you already know where those are, hopefully in your own home or office. But our housekeeping matters. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please don't wave your arms because we can't see you. Please submit them via the question box. We'll try to answer all questions during the webcast today, but if we run out of time or if a fuller answer is needed, we will be glad to answer you later via email. There's a PDF of the presentation that we can autograph for you later. That's in the resources folder. The program has been approved for legal education hours, which is, I suspect, many of you why you're here. So to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, please be sure to complete our short survey. We would like to use adjectives like amazing and I couldn't believe how great it was. Those are our preferred ones. We use your feedback to plan future programs that are applicable to your business needs. That's it for housekeeping items, so we're going to get started with our program. As I said, we're excited to be talking to you today about the Madrid International Trademark Registration System. And in addition to me, I'm joined by my colleague, Don Erickson, who also advises Fortune 500 companies, startups, individuals, small businesses on trademarks, copyrights, right of publicity, and other intellectual property matters. So let's get to it. Here's our outline of what's going to happen today for any of you that are control freaks and need to know everything in advance. So you can just enjoy that at your leisure. We'll move right on to the Madrid System overview. Now, hopefully many of you are already familiar with the Madrid System, but for those of you who haven't dipped your toe in, the Madrid System, as it shows here, is an international filing system. It's a one-stop shop for filing trademarks in many, many countries around the world. So you can file one application through the Madrid System with WIPO, the World Intellectual Property Office in Geneva, and you can extend protections through that one filing office throughout the world. So it's an incredibly efficient system that can engender great cost savings. We'll talk a little bit more about that later. So to keep you awake during the presentation, we're going to ask some questions. The first question, and please pick one. Have you used the Madrid System before? We want to see if we have complete newbies here or if everybody is well-versed. So please pick one of the circles. Can't pick more than one. That would be cheating. But go ahead and pick one. And we'll give you a minute to submit your answers. And let's see what people say. So the majority of our listeners today, we have quite a few, we have almost 61% have not used the system before. Okay, well, then hopefully you'll be able to make a decision whether you're going to do it after the presentation is over. So just to give those of you who have not used the system before might need just a quick overview, the Madrid system is combined of two different agreements, two treaties. One is the Madrid Agreement and one is the Madrid Protocol. This is administered by the International Bureau, the IB. We have a lot of acronyms in trademark law, so get used to it, of WIPO, the World Intellectual Property Organization, and that's in Geneva, not in Madrid. They call it the Madrid Protocol. I believe it was originally signed in Madrid. I can't call it the Geneva Convention because then we would be confused with other conventions that have to do with war and not trademarks. So anyway, it is a central filing system for worldwide registrations. As we said, one-stop shopping for trademark filings around the world. And there are two. The agreement is very old. It was first created in 1891, and the Madrid Protocol came into being in 1996. So it's newer, and most countries are members of the newer one, but some are members of both. So another question, just to keep you alive and interested. How many countries do you believe the Madrid system covers? We have anywhere from 75 to 176. And for those of you who are geography nerds, you may know how many countries there are in the world. So that might give you a hint at which of these answers might be a little bit misleading. And I'm trying to give you a little bit of time to answer so that we can find out how many people actually know what we're talking about. Okay, I know which one I would pick, but then again, I've seen the answers, so it's really not fair. I'll give you another 5 seconds, and let's see what people have chosen. Well, that's very interesting. Most people went for the middle, and that would be 90. Then we had some outliers, some optimists, and some people who are very skeptical of how many people would want to be in Madrid. So what is the actual answer? The actual answer is 122. So some of you got it right, the others of you, nice try. Here's a map of the Madrid members. And the red means that they're members of both the agreement and the protocol. The gray are the protocol only. So as you can see, this covers most of the world. This map is a little bit old, so you would have to color in gray both Canada, that's that country just above the United States, and Brazil. But as you can also see, there are a lot of countries that are not actually part of the Madrid Protocol, primarily in Africa and Central and South America, and somewhat in Asia. So you have a lot of the world, places that most of our clients would want to be, are already Madrid members, but there are certainly holes, and it is not comprehensive. Just some statistics about U.S. companies that are using the Madrid system, and we were curious about this with respect to COVID as to how that would impact the filings. But as you can see, over the years, there has been a trend upward in the amount of U.S. companies that are filing Madrid applications based upon a U.S. trademark. And that's been just going up steadily over the last several years, and it's dropped off in 2020. Also, we don't have a full year, but I think COVID and the pandemic has also made people retrench a little bit while we figured out what was going on with the economy. Also, how many international registrations, the slide before were applications, and then how many registrations have issued with a U.S. trademark as the home registration. And as you can see, other than 2016, I'm not sure why that happened, but the trend has been generally upward over the last several years, and then has fallen off again in 2020, most likely because of the pandemic. So as you see, you get upward of 9,000 to 10,000 in 2019 of international registrations, about the same for applications. But then when you have countries that are designating the U.S., so this would be foreign trademark applications that are filed in other countries, and they designate the United States as one of the countries that they want to extend protection to, you see that it's actually a lot larger. So foreign applicants are using the Madrid system a lot more than U.S. companies are. About 3 times as many U.S. applications from foreigners than U.S. applications going through the Madrid system outward to other countries. So why would you file through the Madrid system? As we said before, you get one-stop shopping for 122 countries. You save a lot of money because you don't have to use a local agent to file as you would with a national registration. You would file directly, let's say, in Canada or China. There are no separate powers of attorney. So you're really saving both time and money by using this system. The applications can be filed at any time. So if you have a home registration in the United States that's 5 years old and you say, hey, I now want to go out to the world, you could do it at any time. There's no deadline in terms of when you have to file for the international registration. And it's simplified, and it's through a centralized office. The cost savings you can see here, this is the cost savings associated with a typical registration in foreign countries from the United States. If you wanted to file your trademark that you have in the U.S. and you wanted to go to Canada, China, the European Union, and Mexico, you'd pay about, give or take, about $4,800 in out-of-pocket fees to the governments in those countries and for the trademark attorneys in those foreign countries. Now, this excludes the fees that you would that would be charged by your U.S. law firm, hopefully us, but those fees will be so low you'll probably not even notice them. I'm not hearing any chuckling, but I'll just move on. So $4,700 in foreign fees for filing directly. Now, if you did that through the Madrid system, through the Madrid protocol, that's a savings. The total would be about $2,500 as opposed to $4,700. So it's about half. So the savings are very significant, and I think in the COVID era, many of our clients are looking for ways to cut costs, and this is certainly one way to do that. Advantages for U.S. filers versus non-U.S. filers. So if you're a U.S. company and you want to file in Madrid, there aren't a lot of advantages vis-a-vis other countries, but you do have the advantage of paying the initial fees and filing through the U.S. Patent and Trademark Office. So there is an easy process for taking your home registration and filing it with the PTO, and then they'll go ahead and do the paperwork and send it on to Geneva, to the WIPO. And there is a processing unit in the trademark office that can help you if you run into any problems. But if you used us to do that, you wouldn't run into any problems, so you wouldn't need them. Anyway, non-U.S. filers have a lot of advantages, and this is why I think it's taken a long time for Madrid to take off in the United States, is that since we are a use-based country, and when we file registration in the United States, for the most part, our domestic applicants have to demonstrate use. So you have to, if you're a clothing manufacturer or a food manufacturer, you can only get a registration for the goods that you've actually used in the United States. If you're an applicant or registrant from a foreign country, you are not limited by use, and you can file very broadly. So you don't have any limitations. So you can file for the kitchen sink and then use that home registration to file broadly throughout the world, even though you haven't used the mark on a wide variety of products. In the United States, if you use that as your home registration, you are limited to the goods or services which you've actually used in the United States, which means that you're at a bit of a disadvantage to foreign filers. Some other disadvantages of Madrid include the fact that, as we said, there are a lot of countries that aren't part of the system, and so you'd have to file directly there. One other big problem is the fact that if your home registration, if you file an application in the United States for a widget, and you then use that application to file throughout the world, and your application in the United States for widget fails within the first 5 years, either you don't get a registration or it gets canceled after you do register within the first 5 years, there will be a domino effect throughout the world, and you will lose all of your Madrid filings throughout the world. Now, it's not the end of the world, because you could try and transform those foreign registrations based on Madrid into national registrations, but it is costly and time-consuming. Another disadvantage is that there are certain maintenance requirements that Don will get into in certain countries like the United States and Cuba, the Philippines, etc., that have additional declaration of use requirements that are not tied to the Madrid system. So if you don't docket those correctly, you might get tripped up. There are certainly restrictions in terms of corrections. Once you file with Madrid, it's very, very hard for an individual applicant to change those anything within the registrations that you've received from the Madrid system. And just to clarify, an international registration, which is what you obtain from WIPO, is simply a placeholder. There's no registration itself. It's a placeholder that gives you the right to extend protection throughout the world. As we've said, in the United States, you can't amend a U.S. application to the supplemental register if you're a foreign applicant, and you can't substitute U.S. filing bases. You can't change the class number, and so a lot of restrictions. Once you file the international registration, it's really hard to change it, so you're pretty much stuck with what you've got. I'm going to turn it over now to Don, who's going to talk about get into the weeds and talk about how this thing actually works and what you do to get an international registration and extensions of protections throughout the world. So Don, go ahead and take it away.
Thanks, Alan. So Alan just went through a lot of the macro details, and I'm here to talk about some of the micro ones. So let's talk about the nuts and bolts of filing. So to apply, a person must be a natural person or an entity that has a real or effective industrial or commercial establishment in one of the countries that's party to the Madrid Agreement or the Madrid Protocol, or that has an establishment in the territory of an intergovernmental organization that's party to the protocol. So the EU, the U.S., basically one of the countries that's covered by Madrid. So starting with your home application or registration from wherever you have that real interest that's required, you file an application from your home trademark office, and then that goes from there to WIPO. But your home, we're going to use this term office of origin, that's where your application originally comes from. So the office of origin files that to the IB, and remember that's the International Bureau of WIPO. And from there, the IB will look at it, not for substantive issues like likelihood of confusion, but they examine formalities. And so they record the application in the International Register, and they publish it. And if they approve it, they'll issue an International Registration Certificate. So that's your IR. And like Alan said, that IR doesn't cover the whole world. It doesn't actually cover anything unless you elect to select certain countries or territories for the EOPs, the extensions of protection. But if you've done that, if you've selected certain countries or territories for those extensions of protection, the IB will notify those contracting parties that you, as the applicant, have designated them as wanting to be covered by that registration. And from there, that basically has the effect of a national or regional application. So after the IB sends basically the application for the EOPs to the territory or countries that you've designated, the offices of those countries or territories will conduct a substantive examination of the applications. And there's a time limit on how long they can take to do that examination based on whichever treaty or protocol they're a part of, either 12 or 18 months. So from there, that office of that country or territory communicates back to WIPO, to the IB, about the application. If that country's office refuses the application, you have to follow the national or regional procedure, which at that point likely means hiring local counsel. But if there's no refusal, the contracting party gives the extension of protection, which has the same effect as a national or regional registration. In other words, that you're covered in that country at that time. So here's kind of the timeline to help those of you that might be more visual to understand sort of how the application transitions from the initial home application through the IB. Then you get your international registration, sometimes called an IR, and then out from there, you get the extensions of protection from the various countries that or territories that you may have designated. So we get some questions from time to time on specific filing issues. Sometimes people think about the questions that Alan mentioned in terms of, well, there's advantages if you're filing from the U.S., there's advantages if you're filing from a different country. Perhaps you have a basis to claim, that real interest that's necessary in order for a certain country to be considered a home country. So maybe you could either file based on a U.S. application or an application that's from another country. And the laws may vary by country, whether you need to have an attorney in that country file the initial home application. For example, in Germany, there's no requirement to have an attorney file the application, but if you don't have an actual commercial establishment in Germany, you have to appoint a German representative. So depending on your circumstance, that may not help you, and you may want to consider a different strategy depending on what countries you have a presence in. So filing tips for the U.S., you can correct registration issues in the home registration through a Section 7 amendment, but we recommend doing that prior to filing for the international application. And similarly, if you need to update ownership of your U.S. registration or application, we recommend doing that before you're filing the international application, because it's the kind of thing maybe you've dealt with the U.S. Trademark Office, and you know that sometimes they can get confused if you filed one thing and then filed another thing, and they don't know exactly what to look at first. So in order to avoid any potential issues, we recommend getting your U.S. application in the exact shape that you want it to be in before filing your international application. So what happens if you have an issue with the application? So the IB may issue one or more notices of irregularity if there are any issues in the international application that you filed. So as we said before, it's not likelihood of confusion, it's not those substantive issues, but it may be something like improper classification of goods or the description of goods, or maybe there's a deficiency in the fees. So on those, the way that you respond to them depends on what the issue is. So if you, for example, had a missing drawing, that's something that the USPTO has to fix. If it's something where you haven't paid the correct amount in fees, that's something that you would fix directly with the IB as the applicant, to pay the fees. And some issues, you as the applicant go through the USPTO to fix with the IB. For example, amending the goods and services or the classification. So the deadline that you have to respond to these, they're essentially like office actions, but they're called notices of irregularity. You generally have 3 months from the date of the notice, which might not be the same day that you get it. So you have to look at the date that's actually on the notice. And so we recommend that you file the response for anything that has to go through the USPTO at least 1 month before the deadline, because the Madrid processing unit will take a little bit of time to process it. And the Madrid processing unit will not process any responses that they receive after the 3-month deadline. All right, so when you're docketing and looking at what's my registration date, typically the IR application filing date will become the registration date. There are certain exceptions, but typically you're getting the benefit of that date that you filed the application. So this is a little bit of technical detail here for you, but the date of the IR is normally that original date that you filed it, provided that the International Bureau receives it from your home country within 2 months after the home country office of origin received it. Otherwise, the date of the international registration is the date on which the International Bureau received the international application. So if you're claiming priority, that you want to get the benefit of an earlier application filing date, the IB will honor that claim if the international application is certified within 2 months. So let's give you an example. If you file the international application with the USPTO on the last day of your priority period, the USPTO will have 2 months to forward the international application to the IB. So it doesn't matter that the IB won't receive it by that date. You're filing it with the USPTO, that's good enough. So certain irregularities can affect your registration date, such as insufficient identification of the applicant or the other issues listed here. And if you correct those issues within 2 months, you can still retain your original filing date. But if you don't correct those issues within 2 months, then your registration date will become the date on which you fixed the last issue, essentially. Other types of irregularities do not affect the registration date, such as fees, payment of fees, or changes to the goods and services. So there's a lot of different details that can make things go a lot of different ways here. But no matter if it affects the registration date or not, you have to correct the issue within 3 months, or your application will be considered abandoned. Okay, if a local trademark office issues an office action or a provisional refusal for an extension of protection, you will, as I mentioned, you will normally need to retain local counsel to try to overcome the local trademark office's objections. So as Alan said, the system isn't perfect because it doesn't cover every country, and also because if you have an issue in a particular country, you may still need to file local counsel, and we can talk a little bit more about strategy and where you might want to file directly for some other reasons, such as, for example, in China, it's almost inevitable that you're going to get an office action, so you don't necessarily get the benefit of a reduced fee by filing through Madrid, but we can talk about that a little bit more, especially if you have questions. So just to run through a few specific docketing issues, there's a couple of issues with Madrid that come up. And one of the most important is the fact that certain countries have certain national filing requirements, like how in the U.S. we have to file a declaration of use between years 5 and 6. That's something that is off of the Madrid timeline. And other countries have requirements to pay fees in 2 parts. For example, Cuba in Japan require payment of fees in two parts, and those requirements are again separate from your typical Madrid maintenance deadlines. A couple of other examples: the Philippines requires a declaration of use within 3 years of the international registration date, or within 3 years of the subsequent designation. We'll talk about subsequent designations as well. So again, these dates are off of the normal dates, so this is something that you need to be careful when you're looking at docketing, that you're not saying, oh, I've got my international registration, I've got my extensions of protection, and I'm good to go. You want to make sure that you're also taking a look at what other filings you may need to make on these extensions of protection. Cambodia is another one that requires a declaration of use. So nothing in particular requires the Madrid contracting parties, that's any country or territory that's part of the Madrid system. There's no requirement for each country or territory to follow a specific numbering system. We asked WIPO, do you have a list of countries that doesn't follow the system? And they said, no, we don't know. Because the U.S., for example, issues all its own serial numbers for applications and registration numbers for extensions of protection. And we are aware that Singapore issues a separate local number to each class within a Madrid application. But again, that's something to look at when you're docketing and making sure that you can try to get the numbers in there that are perhaps different from the WIPO registration number. Updating ownership presents certain issues and is something that we get asked about when you want to change the owner name or entity or address. So to record a change in ownership due to assignment, essentially you use the WIPO form MM5, and you do not need to include, for example, an attached assignment document signed by both parties. You just need the MM5 form. If you want to change the name, address, or legal nature of the entity or individual that owns the trademark, you use WIPO form MM9, and again, just the form. You can't transfer ownership of a registration to an individual or entity who's not a resident of any Madrid contracting party. So that's something to watch out for. You can transfer some extensions of protection, but not others. And you can transfer some goods and services, but not others, if you want to partially move part of what's covered to a different entity and retain part. And if you do that, WIPO will indicate the part that has been transferred as a separate international registration, and that essentially new registration will have the same registration number as the original, but there will be a letter on the end to differentiate it. You may run into issues from time to time with countries that are on the U.S.'s list of sanctioned countries. We had a question about Iran, because Iran is one of the countries that has been sanctioned by the U.S. And under the language of the regulation, only certain transactions are allowed. And the transactions that are specifically allowed do include trademark application and renewal, but there's no mention in that regulation about assignments or updates to chain of title. So that's an issue that you may run into and say, well, we're kind of stuck with that there as it is. And so just make sure to look at the updates that occur from time to time with U.S. sanctioned countries, because that list does change often. Now, as Alan alluded to, you may have some issues if your home registration becomes abandoned. The international registration is dependent upon that home registration. So let's talk about that. It's dependent for 5 years from the date of the international registration. And as Alan said, there is a way to save the extensions of protection if that home registration fails before 5 years. And here's essentially what's going to happen. So within that 5-year period, say you've got a U.S. Registration, and say that it has been restricted or canceled totally or partially. The USPTO will notify the International Bureau about that. They'll say the basic application has been abandoned, or they'll let it know if it registers or is divided. And then what you as the registrant have the option to do is you may transform extensions of protection into national filings in those countries or territories that you have designated. The deadline to do that is 3 months from the cancellation date of the international registration, not your home registration, the international registration. So the ability to transform the extensions of protection is only available under the Madrid Protocol. So if any of the countries that you have the extensions of protection in are only members of the Madrid Agreement and not the Madrid Protocol, you can't do that transformation process. Now, let's say you've got your international registration and you're looking to cover some additional countries or territories. You can do that at any time. Just like when you can apply for international registration at any time, you can add countries that you would like to extend your registration to at any time after registration of the international registration. And what's interesting about that is that the renewal date for those new extensions of protection be the same as the international registration, which seems a little bit counterintuitive. So let's look at an example here. So say the international registration's renewal date is May 1st, 2012. Then you file subsequent designation, and that, say it meets the filing requirements, and then its new effective date is February 1st, 2012. The international registration, including the subsequent designation, will require renewal on May 1st, 2012. So even though that's only a few months before, you don't get the 10 years, you have to pay for everything all at once when that renewal date comes up for the international registration. Okay, subsequent designation. So there's no separate dependency period for the subsequent designations. And this is a question that we get because that 5 years is kind of scary. Like, well, if we lose it within 5 years, then we have to do the transformation and all of that. But here, if you have your international registration and you file additional extensions of protection, that doesn't trigger a new 5-year period. The only 5-year period is the period of time that runs from the original date of the international registration. This is something that may come up if you're doing some new filings now. In certain cases, you can only designate certain contracting parties if the international registration date came after the foreign country joined Madrid. So on that map that you saw, which the latest version that WIPO has is from 2015, there have been a number of countries that have joined since then, such as Brazil and Canada, like Alan mentioned. But certain countries, if they joined Madrid and didn't check a box on a certain particular thing, they won't let you designate them if your international registration is older than the date that they joined Madrid. So looking at these, if you have an international registration back from, let's say, 2010, you can't extend protection to Brazil, India, and the Philippines. But if you got a new international registration now, that's no problem. You can extend protection to Brazil, India, and the Philippines because 2020 is after the date that these countries joined Madrid. So we've got another poll question for you because I'm less funny than Alan and I had to go through some of the drier stuff here. So do all of an international registration's extensions of protection have the same maintenance or renewal date? Your choices are all of them have the same date, all have the same renewal date with WIPO, but may have separate maintenance deadlines in certain countries. No, some have different dates, or none of the above. We'll give you a minute here to look at that. Okay, let's see what you think. Well, let's see, 65% of you have it correct. All have the same renewal date with WIPO, but they may have separate maintenance deadlines in certain countries. We sort of alluded to this a little bit. We're going to talk about it in a little bit more detail. So let's look at renewal. So you've got your international registration. That's valid for a period of 10 years, and that's 10 years from the date of the international registration. Again, not the home registration like your U.S. registration. It's the date of the international registration that you got from WIPO. So you renew it directly with the IB. You don't go through the USPTO for that. You go directly to the IB. There's a renewal form, the MM11, that's on WIPO's website. So don't go to the USPTO. They won't do anything for you on that. WIPO sends you a renewal reminder 6 months before the due date using their European expiry language there, unofficial notice of expiry. You can renew as early as 3 months before the renewal date. So even though they send you the notice 6 months before, you can't do anything yet. You have to wait 3 more months, and then you can file your renewal 3 months before the renewal date. And you also get a 6-month grace period after the due date. If you don't renew, the international registration will be canceled, and the IB will notify all of the designated countries. You may renew in some, but not all, designated countries. And we'll talk a little bit about what you can and can't do at renewal, because it is, again, a little bit confusing and a little bit not intuitive if you're a U.S. practitioner. So it's not possible to record any changes at renewal other than renewing in some but not all countries. So what do I mean by that? If you wish to renew for only some of the goods or only some of the classes, you have to request a limitation, renunciation, or cancellation either before or after renewal. And so to compare to a U.S. application that has registered, when you're filing your renewal of a U.S. registration, you can do all kinds of things. You can delete some goods, you can delete some classes. It's all part of the renewal application, but that's not true for a Madrid registration. With Madrid, there's 3 different ways to change what you have going on with that international registration. And again, it's not intuitive, so we can look at these in detail. So the form MM6 is for a limitation, and that doesn't remove goods from the international registration. It just limits their effect in certain contracting parties where the EOPs are. And a good thing about that is that you can later subsequently designate the goods and classes that are still part of the IR to the EOPs if you like. The option for renunciation is the form MM7. That's renouncing all goods and services in one or more, but not all, of the EOPs. You can later subsequently designate the classes and goods in those EOPs again if you want, in those contracting parties. And the third option is cancellation. This is to wipe everything out, wipe the slate clean. This is the form MM8. You're renouncing all goods and services in all designated parties. You retain the IR, but you get rid of all of the extensions of protection, and you can later refile for the certain contracted parties if you wish. So these three options are not part of renewal. This is separate from renewal, and one of the strategic things to think about with this is when you renew, you're paying for everything all together. So if you want to make changes before you have to pay for renewal, the time to do that is before or after renewal. It's not part of renewal. So WIPO does not have a specific time period that they say you should do this in before or after renewal, but they say you should request it in good time before the renewal date so that WIPO has time to process your request and take the limitation into account when calculating fees, like I mentioned, and also so that the changes will be reflected in the renewal certificate that you receive from WIPO. We recommend as a best practice that you file those modifications, whichever one you're choosing, 6 months prior to your renewal date so that you have plenty of time to not worry about it being processed. So we also want to remind you again of the separate national maintenance deadlines. In the U.S., you have the Section 71 filing, which is like the Section 8 filing that you have to file before the first 6-year period after the registration date. And then also within 1 year before the end of the 10-year period, and then every 10 years after that, you have to file that with the U.S. So if you own a registration from another country and you have an extension of protection to the U.S., these are the filings that you have to make in the U.S. There are similar requirements in the Philippines and Cambodia in terms of needing to file essentially a declaration of use, and we deal with this all the time. It's when you're practicing and managing a portfolio of international trademarks, you think about a lot of countries aren't EU-based, so we don't really have to think about it too much. You want to remember these exceptions so that you don't miss a filing, and these are the kinds of filings that you need to know about well in advance. Especially the Philippines, you need to get a declaration signed and typically the original over to them. So these are deadlines that you want to make sure you're well aware of. So WIPO has a lot of forms that you can look at. So the changes to the international registration would be filed directly with the IB. Here are the forms. MM5, again, is for the change in owner, holder name, entity, citizenship, or address. The MM9 is for change in owner, holder, representative name or address. MM6 for limitation of goods or services. MM7 for renunciation of a designated contracting party. MM8 for cancellation of international registration in whole or in part. And all those forms are on the WIPO website, which is worth poking around if you've not experienced that before. So now we have some time for some questions. I'm sure Alan has been looking over what questions we have received and is ready to answer them or possibly tell more jokes.
Thank you, Don. I appreciate the plug. First of all, we do have some questions. Before we do that, just as a kind of a wrap-up and a takeaway, I just wanted to say, if you're thinking about Madrid, since many of you haven't used it before, I guess the question is this right for your company to be using Madrid? And I would say the answer is I think the biggest advantage, as we've mentioned now several times, is both the ease, the efficiency, and the cost savings. So that's a big draw if you are trying to put a stake in the ground in many countries around the world. If you have some budget pressures, or you're not sure if this particular mark is going to be a winner. So you maybe don't want to spend a huge amount of your budget on trademark filings. this is a way to significantly reduce your costs and still get some coverage. Now, as we've said, the disadvantage is that because most of us will be U.S. filers, most of the people on this presentation will be U.S. filers, we're limited because the U.S. home registration will be use-based. And thus, we'll have a more limited registration in terms of goods and services. If you are lucky enough to be a multinational corporation and you have a real effective industrial or commercial establishment in another country such as Europe, where you can then use a home registration from that country to file for the kitchen sink around the world, then that would make sense. But many of our clients will not have that advantage, and even those that are operating in other countries might be doing it under a different subsidiary or affiliate, or might not have boots on the ground, even if they have a corporation there. So I would say that savings, ease of administration, and ongoing cost savings would be a huge advantage. Also, if you happen to be lucky enough to have an international classification for a U.S. business, such as, for instance, alcoholic beverages. In the U.S., you can file in Class 33 for alcohol, basically just for alcoholic beverages except beer, and that pretty much covers the waterfront in Class 33. So you could use that as the basis for home registration, and you pretty much have eased out anybody who might want to get close to you in terms of goods around the world. But if you're a food manufacturer or a clothing manufacturer, and you file in the United States, you can't file for clothing and apparel, or you can't just file for food. You've got to file for specific items, shoes or canned corn, which means you'll have a much more limited registration should you want to take that U.S. registration and file it around the world. So I think you have to balance budget, ease of administration, and the breadth of your goods and services when you're trying to determine whether or not to use the Madrid system. But in these times, with money being tight for a lot of companies, it's certainly something that people are taking another look at. We did have some questions, and one of them was, if we're registered with the USPTO already, do we have to go in and specifically request a Madrid application? And the answer to that is yes. You have to, even though you have a U.S. registration or application, you have to file a separate form requesting that home registration be the basis of a Madrid international registration, and you would do that through the United States Patent and Trademark Office initially. They would file the international registration request on your behalf based upon your home application or registration. The next question was, do you have a good ID manual for international registration, classification of goods and services that would be accepted by most countries? And I would say, that's a good question because, and Don, you can join in if you want, but I think sometimes the U.S. Manual for the ID manual is different than the ones for other countries around the world. I guess I would probably go to the NICE classifications and use those to the extent that they sync up with the U.S. ID manual, if those would be synchronized and the same. To the extent that they're not, you'll probably get an office action in the individual country if they don't like your specific wording or want it to be tweaked. But I think the extent that you can stick to the NICE classifications, that's probably your best bet. Use that ID manual.
Yeah,
Don,
I can speak to that too, Alan. Yeah, and the U.S. ID manual that's on the USPTO website will indicate within their lookup there if part of the description is part of the TM5. So that'll give you a good idea of at least, the 5 trademark office is what, or within the TM5, which goods they will accept. But I think we should also speak about China, which is kind of a special case. A lot of times you might as well just file directly in China instead of through Madrid because, for example, if you have a U.S. registration, like Alan mentioned, you have to, you can only cover in that what you're actually using. So if you are using, as you said, canned corn, you don't get all of Class 29, you just get, canned corn if that's all you're using the trademark on. And so from there, the only goods that are covered through your international registration based on that U.S. registration is canned corn. And so that's one of the reasons why if you have a real presence in another country that might be better for basing your international registration on, if you are so lucky as to be able to do that. But also with China, one thing we should mention is the subclasses. And so, Alan, do you want to address that?
Yes, in China there are they have a different system, and if you file for one type of, let's say, food product, you might get a registration for that, but there might be 10 or 12 or 15 other subclasses in China that designate other type of food items that the Chinese government would consider to be unrelated to your particular subclass. So in China in particular, I think we tend to file directly in China because they have different descriptions and they have these rather rigid subclasses. And it's been our practice and experience that they don't consider goods to be related the same way that, let's say, Europe would or other first world countries. So typically in China, unless again there's a budgetary issue where you simply just don't have the funds, we would typically recommend filing directly in China, even though it's going to cost you more because you're going to be able to get much broader registration in all those various subclasses. And filing for all those subclasses is not very expensive. It's $10 or $20 per subclass, and you then cover the waterfront and stop your competitors or pirates from being able to use the same mark for what might be in the United States considered related goods. I think those are all the questions that we have. We want to thank everybody for taking the time today. We hope you enjoyed it as much as we did. And just a few things in closing. First of all, please remember that this has been approved for legal education. So please report your hours. You click on the CEU icon at the bottom of the screen. You will receive a certificate of attendance, and that'll be emailed to you tomorrow along with a recording of the webcast for watching and sharing. I'm sure you want to review this many, many times for the laughs, crying, laughing, whatever you did, or sleeping during this webinar. Finally, please remember to complete our survey. We do use this as feedback to plan future programs and for shameless self-promotion. So anyway, this concludes the webinar. We thank you very much for participating. We hope you got something out of it. If you have further questions or like us to delve into something that's particular to you, please feel free to contact Don or me, and we'll be glad to get back to you. Thanks. Thanks, everybody.